Hello everyone and welcome to webinar number 9 of Quantum London, now joining forces with Quantum Computing London. And as you know, for the ones who are new to our communities, we are a group of people interested in the business implications of quantum computing, these technologies which are coming our way and accelerating. So we are very curious about what is going to happen and what is the impacts on our businesses. So we try to explore this by bringing in experts in the field and share their knowledge with the community. So today we are going to look at something we haven't touched on before in our group, and it's probably something we don't hear often at conferences and events, but still very important topic. As investments are ramping up, what we're going to discuss today is becoming more and more of an important topic. So the webinar today will be focused on patents. So software, hardware, algorithms, what can be patented and when should be the right moment to start patenting. To help us unravel that complex topic, we have James Tumbridge and James Varley from Venner Shipley. They focus on this. They will introduce themselves in a second and give us an overview on also, what they do for a living. Together with me, you can see Paolo, the co-founder of Quantum London, and we will have the chat on the side, which we can which you can use to ask questions, and there will be a Q&A session towards the end. But feel free to ask questions as we go along, and if something is relevant, we'll briefly interrupt our speakers and ask the question. Otherwise, we'll leave the questions to the Q&A session towards the end. The event is being recorded, just for your awareness. You will be able to catch up later if there's something missing, and we'll be sharing some comms with all our social media channels, which you also see on the screen at the moment. Without any further ado, I will hand over to James to lead us through their talk for tonight. Over to you, gentlemen.
Good evening, everybody. And I'm the first of the two Jameses. Now, the upside is that if you can't remember what we're called, we answer to the same name. I'm the lesser of the two Jameses, at least in the intellectual capability. James Tumbridge, I'm a partner at Venner Shipley, and I'm joined by James Varley. I'm just going to quickly outline who on earth are we and why should you try and listen. Venner Shipley is a European firm in the UK and Germany, which specializes in intellectual property. So our core business is helping businesses or inventors develop their technology and take it to market, principally by patenting, and James is in the patenting team, and James has great expertise in relation to quantum computing, so I'll let him tell you about himself in just a moment. I head up what we call the legal group, which is the group that deals with the contractual side of people that might want to come along and invest in your technology, people you might need to sign confidentiality agreements with and that sort of thing. At the regulatory side, particularly data protection, I, for my sins, am one of the authors of the Data Protection Act, which implemented the GDPR. And contrary to what you may or may not hear in the news, GDPR still applies. It's now called UK GDPR in our country. What a wonderful acronym. And I can see Fred has asked if he can get a copy of the slides, and Venner Shipley is very happy for these slides to be shared with members of Quantum London. So that's just a quick overview. Basically, we specialize in tech. We specialize in all the legal aspects of bringing tech to market, helping you set up a company, helping you sign contractual documents for investors, and helping you get patents for your great inventions. So James, do you want to tell them a little bit about yourself before we go into the slides?
Sure. So I'm a patent attorney rather than a more general lawyer, and I focus on prosecuting, writing, and opposing patents. A large part of my work is either related to quantum computing or machine learning. I would estimate probably 40% quantum computing and 40% machine learning. And the rest is things like more general software applications and occasionally medical devices, which is a nice change. My background is in physics. There seem to be a lot of physicists in the patent profession. I'd like to think we're the Swiss Army knife of the patent world, in that we can apply a hand to many different things, though others might disagree with me.
Thanks for that. And you'll start to realise why I describe myself as the lesser, because I'm a mere lawyer. I'm a mere barrister, whereas James is a great scientist before he becomes a patent attorney. But what we do is that we operate in technical teams. So James is in the electronics team with a specialism in AI quantum computing, and we have people that specialise in other technical fields, because most of the people in our firm have a master's and PhD in some sort of specialism, whereas I'm a mere failed mechanical engineer who played a bit with electronics when I was a signalman in the army. So I'm the Babio fish. I'm the one that normally talks to the investor that doesn't get the technical matter and puts it into plain English. So I'm going to just do a quick opening. If James could move us on to the first slide, talk a little bit about why on earth the patents matter and why you're here this evening. James is then going to walk you through the detail of the patenting system and some of the unique aspects around obtaining patents for quantum technologies. And then at the back end, I'll come in to join James on any questions that you may have posed at that interface between the investors and the legal reg and so on. So James, if you could move us on to the next slide.
I believe I have done so. Can you see that?
Oh, for me, it's still showing the first slide.
James.
Okay. Right, sorry, apologies too. Let me see if I can get this to work again.
While James does that, I'll add that I'm hoping to assist Quantum London going forward, because being a strange sort of person, I'm also a City of London councilman, and we're hoping to support the activities of Quantum London to enable you to engage as deeply as possible with potential industries such as the insurance industry, which many of the major insurance companies are located in the ward I represent. So hopefully this will be a good starting place to get to know more of you. I think you can probably see the wording on the slide, even though it's not quite as large as I might like. So I'm going to start talking about that so that you don't lose too many minutes. Now, this is nothing more than a laid memoir about what on earth is a patent. Some of you might know and some of you might not. I'm really unsure. So we've pitched this on the basis that you probably heard the word patent, but might not know too much about them or how you get them. First of all, patents are the sort of the king of the intellectual property world, even though things like trademarks can last in perpetuity and patents only last for 20 years. Generally speaking, any significant technical development, people tend to look to a patent because it gives you an absolute monopoly right. So you've come up with something impressive that enables you to hopefully go and get a patent. And for 20 years, either you can tell everybody else to pay you to do what you've come up with, or you can keep them off the market. So as the second bullet point shows, it's an investment protection mechanism. And actually, when it comes to the business end that I tend to engage in, sometimes we have quite frank conversations about the fact that it's occasionally worth seeking patents, even if you don't think you're the kind of organization that wants to litigate and go to court to enforce your rights, because it scares certain people away, or at least gives you negotiating leverage. Which brings me on to the point of investment return, because there are different ways to make money from your technology in conjunction with a patent. You can have the fact that you've come up with it and then you take it on to others and license them, and they'll pay you a royalty. And in a lot of what we do, many of our clients, that is their approach. They focus heavily on the R&D and then take a license fee for those that use their tech. Others, of course, amongst our clientele may well create devices and wish to be the only party that's offering that software solution, that device, etc. And again, what this is doing is it's ensuring that within your 20-year monopoly from your patent, you'll be able to earn back the money you've spent on the R&D side. Values to investors. The problem with the finger in the air, the intellectual property, is that we can all recognize in a value economy the value of technology, the value of innovation. But when it comes to getting an investor to put some money into your startup or work with you, they like to see something tangible that they can deal with. And as a result, having patents can be quite a good way for startups to assure investors that they are investing in something, forgive me for mixing the expression, but something tangible, when of course, in fact, this is all about intangible rights. There's also the competitive advantage, either to keep people off the market, slow them to market, or to ensure that you can't be removed from the table once you've started explaining why your technology has great value. And the final value, which we see a lot in at least the electronics space, is cross-licensing. Most commonly, you'll see that in the world of mobile phones and other digital devices. A given device will often be covered by 200 plus patents. Those patents don't all belong to Apple or Samsung or whoever it is manufactured your device. So you get those large companies cross-licensing. The little anecdotal story I love to tell at this moment, true story, even if you think it sounds incredulous. About 15 years ago, IBM hired in a new head of legal. Their background was as a general counsel in a food company. And they immediately cut the patent budget and said they weren't particularly keen on all this patenting business, which scared the life out of the patenting department and many of the people at IBM who had spent their careers building up technological innovation that was protected that way. They could not get this individual to pay attention because when he'd been at the food company, apparently somebody's patent had kept him from launching a food product, and he therefore thought that they were just anti-business and not a good thing. So when he went home one evening, they disassembled his IBM computer and placed red stickers on the components that were covered by IBM patents and blue stickers on everything else. And when he came back in the morning, he found a desk covered in parts and only 20% of it covered in red stickers. And apparently that was the magic moment where he suddenly realized why patents had some value, because otherwise the competitors could keep your products from market. So that's just a really quick overview on what's a patent, economically speaking, all about. Now I'm going to hand over to the brighter, more impressive James to walk you through how you get a patent, and in particular, the challenges when it comes to software and quantum. And we're watching the chat. If you've got questions, by all means, throw them in and we'll answer them as we go or at the end. Over to you, James.
Thanks, James. Good evening, all. Apologies for the slide situation. I don't seem to be able to get the full screen slide show to work, so I'll do my best with what it is at the moment. Right, so this evening's talk. Oh no, I can't get it to work at all. Can you see the full screen slideshow?
I can see the slides. It's in a sort of partial. It's not full screen. It's on the one I was talking about.
Okay.
Yeah, introduction now.
Good. Okay. So to begin with, I'm going to my part of the talk is divided into two sections. I'm going to give a general overview of patents, sort of following on from what the other James has just talked about, but focusing on what are the actual requirements for getting a patent and how you get one. And then in the second half of the talk, I'm going to talk about how quantum technologies relate to patents and some specific things you need to consider when dealing with those. How do I get to the next slide? Sorry, this is not going well.
And you can tell me how to move around. Give me just 1 second to bring it on the screen. No worries.
Excellent. You can move on to the next slide, please. I'd say, as James mentioned earlier, a patent is a type of intellectual property right that protects new technical developments, and by technical development is what we mean when we use the term invention generally in the patent world. The idea of patents is that they encourage people to share knowledge. They represent a deal between the inventor of an invention and the state, which is essentially that in return for you telling the world how your invention works, and therefore letting other people be inspired by it and develop it further, you get a 20-year monopoly to that invention. So, and the other thing that is important to note about patents is that they're territorial. So if you have a patent in the UK, you can only, you have a monopoly in the UK for that invention. If you have a US patent, you have a monopoly for that invention in the US. So you need to apply for it in multiple jurisdictions if you want worldwide protection. Can I have the next slide, please? So when we say monopoly right, what does that actually mean? What it means is you get if you have a patent to an invention, you can prevent other people from implementing that invention. Essentially, in UK law, what that means is you can stop other people from making your invention, from disposing of it, by which we mean selling it or giving it away, using it or importing it, or anything, or keeping it, which is essentially storing it in the warehouse or anything like that. Similarly, in some patents we don't just claim products, we claim methods as well, and you can prevent people from using those methods or offering to perform those methods for other people, or you can protect the product that results from that method as if it were a product that you claimed as well. Can you move on to the next slide, please? It's really important, and I can't stress this enough, that a patent does not give you the right to perform your invention. A lot of people get confused about this. Even trainee patent attorneys have a problem with it to begin with, that if you have a patent, there are still things that can stop you from performing your invention. As James mentioned earlier, if someone else has patents to the underlying technology or some subcomponents of your invention, then they can stop you from using them in your invention. And you may have to consider cross-licensing or something like that. There may be other things that stop you from implementing your inventions. For example, if you're patented to a drug, you might need regulatory approval to sell your drug, or very simply, your patented invention might be illegal. I mean, technically speaking, you could get a patent for many things that are illegal. You could probably get a patent for a method of purifying cocaine, but it doesn't necessarily mean that you can perform it without falling foul of other laws. Can we have the next slide, please? So that's what a patent is and what it does. So the next thing I'm going to talk about is what are the requirements for getting a patent. Now, a patent itself is roughly divided into two main parts. There's a specification and some claims that go with it. Now, the specification is a written description, and possibly with some figures as well, that describes your invention in enough detail that someone in your field could take your patent application and work out what your invention is and how they could implement it. This kind of fulfills the first bit of your bargain with the state, you telling the world how your invention works and how you can implement it. One important extra thing about the specification is that once you've written your specification and submitted it with an application, in the future you're limited. You can make limited changes to your application, but they're limited to what's been described in your specification already. You can't add new things to it. Can we have the next slide, please? So the second part of the patent application, and probably the most important part is the claims. Now, what the claims are is the definition of the legal monopoly that you want. They're like the thing you want to protect. Each claim is like a one-sentence description of what your invention is, and puts in all the essential features and how it works, without being too constricting and putting in extra limitations that you don't need. Now, I say the claim is a sentence, but a sentence can be very long. It's not uncommon to see claims that are about a page and a half long, just one sentence. But to get a patent granted, the claims in it have to be novel, inventive, and they have to not relate to some kind of subject that's been explicitly excluded from being able to get a patent in. Now, I'll go through each of these individually next, but I just wanted to point out that when you're claiming something, there are an awful lot of pitfalls that someone can fall into. So much so that the US Supreme Court has said this quote about patents, that the specification and claims of a patent are one of the most difficult legal instruments to draw with accuracy. So I can't probably emphasize enough how much of a good idea it is to get some advice, even if you're doing it yourself. Get at least a little bit of advice about how the claims to your patent and what you should do with them. Can we have the next slide, please? Right, the first requirement to get your patent granted is that your claims are novel. What we mean by saying that your claims are novel is that they must have at least one difference in them over any single thing that's been publicly disclosed anywhere in the world or in any language. So in principle, it doesn't matter what language there is or how difficult that thing is to access. As long as it's publicly available, you've got to have a difference from it. So even if someone has disclosed something that's the same as your invention and is written in hieroglyphics and hidden away in a library somewhere up Mount Everest, that doesn't matter. The fact that it's publicly available means that you've got to be different from it in order to be novel. However, it doesn't really matter for the purpose of novelty, how big that difference is. It can be something pretty trivial just to get novelty over what's already been disclosed. As an example, if you imagine that Mr. Ford has only ever produced black cars, and you trying to claim in your patent a red car, that's a difference, and that will give you novelty over what's gone there before. Moving on to the next slide, though. If you could please, yeah, where the size of the difference comes in is in the inventive step. But what we mean by inventive step is that the difference between your claims in your patent application and the things that are currently publicly available must be non-trivial. They have to be like not an obvious difference. So going back to our example of the Model T Ford, if your difference between Mr. Ford's cars is that your cars are red and his are black, then that's a pretty obvious difference, and it's unlikely that you're going to be able to prove that that's inventive over Mr. Ford's cars. Now, I'm not saying it's impossible. There are some situations where it might be possible, but it's going to be very, very difficult. Now, inventive step is quite difficult in terms of how it's judged. It's judged through the eyes of a fictional legal person called the person skilled in the art. And who this person is there's someone who works in your field who knows everything about your field. They know all of the documents out there. They know everything that's available in your area. They're like a complete expert, but at the same time, they have no creativity. They can't make any inventions themselves or think of anything new themselves. They just do the kind of standard things in your area when they try and solve problems. Now, that can be a bit of a difficult concept to grasp. So as a rule of thumb, a good way of thinking about inventive step is what problem is your invention trying to solve, and how does your invention solve that problem? And if you think that your solution to that problem is something that someone would not immediately come up with in your area, then that's a good rule of thumb to suggest that it's inventive. Can we go on to the next slide, please? So the third requirement is a little more complicated again, and it's and we'll talk about it more later in relation to quantum technologies, but that's excluded subject matter. Essentially, there's a list of subjects for which you can't get a patent for. And those subjects typically include things like business methods, mathematical methods, and computer programs. Obviously, these ones will be ones that will be important in our quantum discussion later on. Mental acts, aesthetic creations, etc. You also can't get a patent for things which are contrary to public order and morality, which sounds quite broad, but in effect it really only means certain types of biotech inventions and certain weapons that are banned under international treaties. Finally, there's also methods of surgery, therapy, and diagnostic methods. You can't get a patent for those, but I should point out that surgery, therapy, and diagnostic methods is usually interpreted very narrowly. So you can get a method for things like drugs, but you can't get a method example for, a patent, for example, on a method of doing heart surgery. Essentially, that's to stop doctors being infringing patents when they perform surgery on their patients, which might be emergencies. Can we have the next slide, please? So those are the three main requirements for getting your patent granted. But in terms of the actual process itself, how to get a patent, the first thing you need to do, probably, as you've probably worked out, is draft your specification and claims and write them, prepare them. You then submit them to a patent office, usually of your choice, but there are some restrictions in some countries about whether or not you have to file in that country first, or you can file abroad without any penalty. And you pay some fees, and the patent office will search and examine your application, by which they look at it, they look at your claims, they see if they can find some other documents that are out there that do the thing that's you're claiming in your invention already, and then they assess them against those three requirements that we described before. If the patent office think that those three requirements are met, they will grant your patent, and that's pretty much it. You just need to pay the renewal fees to keep it in force, and enforce it whenever you find anyone infringing it. If the patent office don't think that it should be granted, which is in most cases usually the case, at least for the first time, they write to you laying out what their objections are and why they don't think your patent should be granted. They then give you an opportunity to argue against them or make changes to your claims, and usually there's a back and forth that goes on a few times till either eventually they grant it or they refuse it. As I mentioned before, a patent is a territorial thing, so at some point you're going to possibly want to consider filing in other countries around the world. It'll be quite expensive to file in all the countries you want to right off the bat before you even know if your patent is novel and inventive or anything like that. So there's kind of a 12-month period from when you file your first patent application in which you can file other patent applications to the same thing in other territories without there being any problems. Can you move on to the next slide, please? So that's a relatively brief introduction to the world of patents, but I'm now going to move on to talk about things in the patent world that specifically relate to patenting quantum technologies. And to do this, I'm going to split quantum technologies into two sections, and each of which has different considerations attached to it. On the one hand, there's hardware, by which I mean sort of the components of a quantum computer, which include qubits, readout devices, quantum control devices, so on, even the whole quantum computer itself. The other section is quantum algorithms, by which I mean whatever you're going to perform on your quantum computer, whatever algorithm you're going to perform. Things like quantum assisted optimization, simulations of various models, error correction schemes, famously Shor's algorithm for factorization, anything like that. Can we have the next slide, please? So on the quantum hardware front, there's, from a legal perspective at least, there's not any particular complications to getting a patent for quantum hardware. It doesn't really usually fall into any of the excluded subject matter categories. So as long as it's novel and inventive, you'll be fine and your patent will be granted. It's pretty much treated the same way that any other mechanical invention or electronic invention is treated, like a car engine or your classical computer. So in that respect, it's relatively easy. That said, there are some things that are specific to quantum hardware that you should probably bear in mind, and also whenever you're claiming things more generally. The first thing to consider is like what actually is the bit of hardware that you're trying to protect, and who are you trying to prevent from using it? If you imagine you've invented a new type of quantum qubit or a new type of quantum readout device, then your first thought might be that you want to just claim that device itself, and you will stop, so you can stop people manufacturing that device. But you also probably have to think that maybe I also want to claim a quantum computer, a full quantum computer itself that has my device in it. In that way, you can stop people from using a quantum computer with your device in it. And from a damages perspective, if you ever have to sue someone or take action against someone who's infringing your patent, maybe having a claim to the whole computer itself rather than just a small subcomponent of it will ultimately result in you getting more damages, and therefore ultimately makes your patent more scary for your competitors. Something else to consider is when you're claiming your hardware, is to try and avoid claiming the hardware in operation. If you think about this, if you've invented a new component of a quantum computer, the people you really want to stop potentially are the people who are manufacturing that component for use in the quantum computer later. So if you claim the specific operating conditions of your component, such as say a qubit that's operating at a particular temperature, then you won't necessarily catch the people who are manufacturing the component itself, because they're not going to be cooling it down to an operating temperature. Someone else is going to be doing that. Now, it's not impossible to catch people for patent infringement like that, but it's much harder than if you had a claim that doesn't restrict use to specific operating conditions. Another thing you might want to consider is that, at least in the near term, quantum computers are not going to be something that everyone has. They're going to be very few in number. They're going to be remote from the end user, and they're going to be in a very limited number of locations around the world. It's probably a good idea to find out or work out what those locations are going to be. So I'd imagine them largely going to be big national laboratories or universities that have the funds to be able to build these super expensive things, or private institutions like Microsoft and IBM. Can we have the next slide, please? So quantum hardware is, from the legal perspective at least, relatively straightforward to get a patent for. Where things start getting complicated are protecting quantum algorithms. Now, as you may recall from before, when I was talking about excluded subject matter, I said mathematical methods and programs for computers are excluded from patentability. So in principle, you can't get a patent on them. However, that list that, at least in Europe, in the European Patent Convention and also in the UK, the list of things you can't get a patent for has this sentence at the end that the list applies only to the extent for which a patent or patent application relates to such subject matter as such. Well, what does that mean? That almost sounds like gibberish, but what does it actually mean? Can we have the next slide, please? So people have argued about this for many years, and eventually, at least in Europe, the European Patent Office has come to the conclusion that what this really means is that if your algorithm, your mathematical method, or computer program is technical or has technical character, then you can get a patent for it. And if it doesn't, then you can't get a patent for it. This is not particularly helpful itself because they don't define what they mean by technical. So what does technical actually mean? Can you have the next slide, please? Well, in an almost circular definition, the Patent Office, the European Patent Office, say something is technical if it solves a technical problem. As you are going to soon become aware in this talk, the European Patent Office love the word technical, but they really dislike defining what it actually means. So the next question you might ask yourself is, so when in relation to mathematical methods and algorithms, what does solving a technical problem mean? What's a technical problem? To answer this question, the EPO have developed two further questions that they ask, and if the answer to either of these is yes, then you can get a patent for that subject matter. It's not excluded subject matter anymore. The first question is, does the algorithm have a technical purpose? And the second question is, when you implement the algorithm, does its implementation involve technical considerations? I'll go into these in a bit more detail in the next slides, but as you can see, again, they love using the word technical. So the first question, technical purposes, does your algorithm have a technical purpose? This relates to the kind of overall purpose of your algorithm. What is it for? What is it doing? And the EPO say under their practice that if the purpose of your algorithm is technical, then it's not excluded. Again, they don't say what technical means, but at least in this case, they give some examples of things they explicitly do consider to be technical. Some of these are listed here. So controlling a technical system, which means if you use your algorithm to control a robot or some piece of industrial machinery, then that's considered technical. Image, audio, or video analysis or enhancement. So things like super resolution or classifying videos, they consider that technical. Encryption, encoding are other examples. And simulations is something that they sometimes consider to be technical and sometimes don't. I put a question mark here because unfortunately at the moment there's a big case going on in Europe about what simulations exactly are patentable and which ones aren't. But yeah, we don't know about that, what the result for that is going to be at the moment. Can we have the next slide, please? So unfortunately, there's not really a list of things that are definitely not technical, but typically things that are not considered technical are anything that's related to business, finance, or administration, or things that are purely mathematical, like, for example, factorization. So Shor's algorithm, for example, would not be considered something you could get a patent for. Get the next slide, please. Sorry, I meant to add at the end of the last slide. So in practice with quantum technologies, we have a bit of a mixed success with this technical technical purpose question. As you probably are aware, a lot of quantum algorithms are very general and relate to performing specific mathematical operations efficiently or quickly compared to a classical computer, and they tend to fall into that that kind of being a purely mathematical method exclusion, and therefore don't get considered to be technical. So some types of algorithm do, though. I noticed someone in the question was asked about error correction algorithms. Could they be patented? The answer is yes. We've had quite a bit of success with error correction codes, particularly the surface code, getting patents for those. But other things like, as I said, factorization or simulating the Hubbard model, things like that, we don't have so much success with, at least using the technical purpose approach. The second question, though, does give us a bit more of an advantage in quantum computing. This question, how is your algorithm implemented in hardware? This question really means, like, when you designed your algorithm, did you take into account any aspects of the hardware that it might run on in the design of your algorithm? Did you adapt any steps of the algorithm so that they will run on your hardware? Now, for classical algorithms, we don't usually have much success with this approach because everyone has a general purpose computer at home, and programs are generally written to run on general purpose computers. So adapting them for a specific hardware isn't something that comes up a lot because the hardware is a general purpose computer. It doesn't have any special properties. However, in quantum computing, we do have a lot more success in this approach. So could you go to the next slide, please? And it does seem that this approach is almost ideally suited to a lot of quantum computing algorithms, especially in the near term. So one thing we know about near-term quantum computers is that they're likely to be very limited in capability. They're going to have a very small number of qubits, a very limited number of qubit gates that they can implement. The coherence times in them are likely to be quite low, so you can only perform very short algorithms on them. So these are all the sort of things that the EPO or the European Patent Office are looking for when they say, are you adapting your algorithm to a specific technical implementation? So if you're adapting your algorithm to work within the constraints of the quantum computer that you've got available, then it's very likely that they're going to consider that to be technical, and therefore you can get a patent on it. We've had some success in things like variational quantum eigensolvers and optimization algorithms using this approach, where you've got a part of your algorithm that runs really well on a classical computer, and then a part that runs really well on a quantum computer, and you kind of split the method up between the two and work out where the most efficient splitting up of that method is. That kind of thing is usually something that you can get a patent for. Can you have the next slide, please? So that's brings us to the end of my section of the talk. So in summary, there's a lot of potential for getting patent quantum technologies. For quantum hardware, as I mentioned, probably the most important consideration is how the hardware is going to be used and where it's going to be used. For quantum algorithms, the thing you've got to bear in mind is whether or not your algorithm is technical, and whether you can squeeze it into one of those two questions, whether it's got a technical purpose or whether it's got a specific technical implementation. It can be easier to get that in classical algorithms for that second question that I mentioned. As a final point, the thing I want to emphasize is going way back to when I was talking about inventive step. Probably the most important thing to bear in mind and have in your head when you're considering patenting something is, what problem am I trying to solve with this invention, and how have I solved it? And that brings my part of the talk to a close. So thank you very much for listening, and thank you to Paolo and the people at Quantum London for giving us this chance to speak to you.
Yes, James,
Are there any questions?
that was great. And as the questions have been rattling in the sidebar, I've been taking some notes and trying to make sure we won't miss any of them. And there's some great questions, many of which I'm going to throw in James's direction, particularly the last one, which I think is actually perhaps where we should start, because it's probably the thing most people want to take away about whether or not you can get a patent for quantum algorithms and software. And I think that the point I want to make as the salesman on James's behalf is that this is something that Venner Shipley sort of specializes in. We've got the largest electronics group in Europe, and I think we've had quite a bit of success. So do you want to just touch on that, James?
Yes, sure. So as I was mentioning in the talk, although at least in Europe and the UK and most jurisdictions in the world, mathematical methods and computer programs are listed as being excluded, those exclusions are interpreted quite narrowly. So you can get patents for algorithms and mathematical methods and so on if you can show that they're technical, if they solve a technical problem. If you're using them for something that the patent office considers to be technical, that's good enough. And if you've adapted your algorithm so that it runs on specific hardware, that's also good enough to be able to get a patent on it. The situation is slightly different
on that, James, because probably those listening are at your level of genius and not at mine. But in case there's anyone that's more of a pleb, I mean, I sometimes, when I'm breaking it down to explain the technical effect, have an example which I hope you'll like. At least I've done it with our colleagues, and they've not said no. But I often think it's easiest because the EPO, the European Patent Office, for those that are listening, hasn't always given great guidance on what is and is not technical. And I've been to many great lectures by very clever people arguing about what it means. I think one of the easiest examples is if one imagines a robotic arm that helps assemble something. You can actually do a data analysis and realize that the movement of the arm in a different configuration would produce whatever this thing is faster. And the real solution to that is in the software. And so you can't have a software patent, but because the software is having a technical effect, it's making the arm move in a different way, you can get a patent. And I find that a helpful way to think about it. But is there a better way to think about it, James, or does that sort of encapsulate the technical effect most commonly used?
That's a very, very good way of thinking about it, and that is, as I mentioned, if you can go back a couple of slides, please, if that's possible. When I was talking about, sorry, keep going back to when we have the two questions on the same page. So that's kind of, thank you, that's perfect. Does an algorithm have a technical purpose? That's what we mean by that, in essence. Yeah, does it have some effect in the real world, in inverted commas? So that's a great example of that.
We've got quite a few people asking specific, can there be patented questions? And I'll go through those in a moment with you. Let me try and pick up one or two others. James, you referred to a case, and I believe that's the G1 of 19 case. Now that's being handled by our colleague, Pav. I'm going to try and explain what that case is briefly because someone asked, and you can correct me. But that's a case where the algorithm was simulating pedestrian movements to help people use it in planning. So you could plan a railway station or an avenue or whatever. And it was initially struggling to overcome the inventive step because the examiner felt that modeling didn't have a technical implementation. And I think, James, if I've summarized that fairly, we had the appeal a few months ago, but we're waiting for the outcome. And I don't think we know exactly when, but we're hoping that sometime in the next couple of months, we might get a decision.
Yeah, that's correct. And as you say, that case is about modeling people moving through buildings, and the kind of question they're trying to answer is, okay, if we model people moving through buildings, that might result in a better building plan and a better building in the future. But do you actually have to claim the step of building that building for it to be technical, or can we just say that simulating the people is enough, that eventually if you did build it, you would get a more efficient building design? Or do you actually have to build the building to get the effect? That's I think, one of the main questions that case is considering.
So then I'm going to move us back to the top of my list that I was writing down. We had 3 questions that I think we can take together. One is about whether or not software and financial algorithms can be protected, which I'll ask you to comment on in a moment. But there were also questions about territories and scope. So let me start with the easy bit. Patents exist. They are granted by a given government. So they're territorial. They apply to France or the United Kingdom or the United States or China or wherever. So technically, you've got a couple of hundred countries around the world where you can go and get your monopoly right. We would love it if you stepped forward and said you wanted to do that, because it's several £1,000s per country, and that's where patent attorneys might make a bit of money. But the focus that you should have about that territorial aspect is when I'm practically advising my clients about the commercialization, it's to focus on where do you build and where do you sell. So if you're unlikely to have people marketing and selling whatever it is you come up with in Mozambique, then we don't go and file anything in Mozambique. I mean, that's the simple point. And we have something called the Patent Cooperation Treaty that enables you to file over 36 months at a staggered pace around the world and spread the costs of these things. So that's my quick summary on the territories and scope and how you work out where you need them. And the other point is that there are some significant differences. So the US is a bit of an outlier. Its approach to patents is quite distinct to most of the rest of the world. In one aspect, for this conversation, it's perhaps positive because they're a bit more open. Basically, the Americans let you patent anything is the sort of the starting place. So software and business methods acceptable in the US. Here in Europe, the tradition is not. And fun enough, going back to my favorite company of today's talk, IBM, they were the sorts of companies that didn't want software being protectable, because in the 1970s, when our law was written, they thought the value was selling you the hardware and they wanted the software to be freely available. It's moved on. Software has its own value. So I would say that's the sort of starting place. And I think going back to that robotic arm analogy, James, would you agree that the thing is, the starting place is you can't have financial algorithms, software protection in Europe unless you come to a really clever patent attorney?
Yes, pretty much. The patents in Europe and most of the world outside the US, whereas they're like the Wild West, some kind of crazy outlier compared to everyone else, that patents for financial algorithms are extremely hard to get outside of the US. You really have to show that, in Europe at least, you really have to show that you've adapted your algorithm somehow to take advantage of some specific thing inside your computer, and the chances are, if you've done that, your algorithm is going to be more general than just financial, the financial area anyway, and it's probably something you want a more general patent to. So yeah,
I just try and put it in another example because I've been working with a client on this. James wasn't handling the patent matter, but we have a client that's filed patents where actually the algorithms and the AI are really important because it's about learning, and it's what it's doing is it's scanning documents, and it's scanning a very wide range of documents, the insurance industry specifically, where there are key aspects in any insurance document going back over X hundred years, but all the documents different. And what this is doing, and we're working with the London insurance market and Lloyd's of London on behalf of the client, it's going to learn over time. And the technical effect is how we approach the patenting aspect, because it's about taking that scanning and what it learns to the technical effect of the ability for a better way to gather together insurance documentation. I mean, I'm being a little bit jumpy in the way I try and explain it, but I think for those of you asking questions about that, the reason I say you need a good patent attorney is you need to talk to someone like James who can find the technical effect, who can show that the algorithm is doing something useful. I mean, that's the heart of that point. I don't know much longer we've got, probably about 5 or 6 minutes. I want to try and move us to some other questions. So I didn't properly take this down. Martin Mackin asked a question about patent's nature, which I didn't quite understand, but I think what he was saying, and if you want to put in the chat box if I've got this wrong, he was asking about quantum patenting, differencing between hardware and software, and perhaps James you can comment on that, because I think you specialise in one area and colleagues specialise in others?
Yeah, so I specialize in patenting the algorithmic side rather than the hardware side, and I've got a colleague who does most of our hardware patenting for quantum technologies. I mean, as I said in the toolkits, there's different considerations for each of them. Hardware is typically easier to get to overcome these legal issues about what's excluded and what's not. But when you're dealing with software, you have to take into account this whole technical effect argument as well. And that's probably the biggest challenge for the algorithm side, is that it's usually a lot of these algorithms are quite new, so we don't have a problem with novelty, and if we can get them to be technical, then they would probably be inventive and be granted. But overcoming that technical effect step is the hardest bit for algorithms.
So I think I can group the last set of questions into three, and I'll take the easy one for myself. For my sins, I'm actually an advisor to the UK government, so I've been quite involved in Brexit. And there were some questions both about the Unitary Patent Court, the European Court, the European Unitary Patent, and about Brexit. So the thing I like to stress is that actually our friends in Brussels get very worked up about this. They hate the fact there's something called the European Patent Convention, operating something called the European Patent Office, and it's got nothing to do with the EU. It's quite separate, quite distinct, and in fact they're so upset about it that they renamed the office that deals with trademarks the European Union Intellectual Property Office, which is terribly misleading because it doesn't deal with patents. So what I'm really trying to say is Brexit doesn't matter when it comes to patents, because the European Patent Convention has about 45 countries involved in it, so it's much bigger than the EU. And the wanted court, which I actually got the UK government to bid for when I was advising David Cameron back in the day, was intended originally to be a community patent court available to everybody from Morocco to Iceland. There's a big political debate that I could do an entire session on separately. So the European Unitary Patent Court will not be proceeding with the United Kingdom or Switzerland or any of the other non-EU jurisdictions. Whether it goes live at all is actually all down to a legal proceeding which is in Germany. They've already had 2 challenges and everyone thought that was it. The German Parliament re-ratified the agreement to let it start, but there's a new constitutional challenge. So watch this space. Happy to come back and talk to Quantum London about the joys of European politics and how they impact patent another day, which lets me move on to the last 2 groupings. So the first one was, we had a couple of questions, James, about what countries are most active. Where are we seeing patents originating first filing, I think is the question really, in relation to quantum matters, and any particular trends about what is being pursued.
That's a very good question. So from what I've seen, a large number of the quantum patents originate from the US, and also seeing more from the Far East as well, and fewer from Europe. But it's largely, by a long way, the ones that I've seen are usually from the US first finding.
Yeah, in fact, we have quite a lot of Californian clients in this space. So I'll group the last 3 or 4 together. So there's one question that's just coming about how savvy are patent examiners when it comes to quantum tech. So I'll let you go to that in a moment, James. But on the back end of it, there were some questions about whether network architecture can be patented. Forgive me, not familiar with the acronyms, VQE and QAOA, but perhaps you are, James. And there was also something from Emmanuel about an SW chip. So perhaps, James, you could just talk a little bit about examiners' comfort level with quantum, and if you followed what I was referring to about network architecture or those acronyms, do share.
Okay, I'll do my best. So our patent examiners quantum savvy? Some of them, yes. So the patent examiners tend to, when they examine patents, the Patent Office divides them into specialist subjects. So there are patent examiners at the European Patent Office who just examine quantum computing inventions, and they're usually very, very good at it. So yes, they're quantum savvy. Sometimes you get some people who aren't, who they've sort of accidentally been assigned something that's outside their comfort zone, but for the most part, yeah, they're quantum savvy. Regarding the acronym things, variational quantum eigensolvers and things like that, yes, you can get a patent on those if you can show that you've adapted the method somehow for the quantum to run on the quantum computer or the specific hardware of some type of quantum computer. Regarding network architectures, if you mean internet network architectures, I'm not sure, but ultimately the question always comes back to, does it produce some kind of real world technical effect? If your architecture is like more efficient at routing packages and things like that, then sure, you can get a patent on that. If it's just something that's more easy for a human to understand, that's not going to be so easy to get a patent on.
That's great. Now, James, there's three final things in the chat. Paolo's helping us wrap up. I don't know whether you want to just touch on the Emmanuel comment or the Jim Walker comments, if there's anything you think you've missed. Last couple of. So the first one from Emmanuel is my attempt. He was referring to an SW chip, which I wasn't quite explaining properly, and he said he's talking about software based in a self-test.
I'm afraid I'm not familiar with that, so I'm afraid I don't think I can answer that question at the moment.
Fair enough. Well, in that case, look, I hope from the great interaction and the chat box, which I've tried to keep an eye on, this was helpful, and thank you so much for letting us join in.
Fantastic, James. And James, yes, thank you. That was very helpful. Very briefly, some messages to the community before we wrap up. So thank you everyone who joined. There's a bunch of things planned for the next couple of months. We've not been particularly effective at scheduling them into Meetup or LinkedIn, but they will follow over the coming days. For example, we do have a session planned with Rigetti and Standard Chartered Bank, which should get into some very interesting things, both on the financial services usage, but also on the UK quantum computer that Rigetti is building. Next Monday, we do have session 2 of the Quantum London coding community. For those of you who were involved in session 1, please do join for session 2. And those who weren't able to join, but would like to actually turn your hand to practical coding of a quantum computer, then please do join in, follow the various online channels to understand what sort of precursor work you need to do. Let us, as ever, know of any particular speakers you'd like, and hopefully we can arrange those. And there were some questions at the beginning in chat about recruiting and job opportunities. We'll look at what we can do in terms of pulling those together and sharing any opportunity there for those of you either directly or friends and colleagues who are looking for opportunities. So really, all it leaves me to do is to thank James and James. That was interesting. It was fluent. It was incredibly relevant and practical for people. So, you know, a very effective use, I think, of an hour of people's time. So many thanks to yourselves and to Venner Shipley for the support. We look forward to having you back maybe in 6 months' time to let us know how things have evolved. Thank you very much. Good luck in 2021. So, good night to you. Good night to everyone. Cheerio.